Welcome to RD Investigations, Rubber Ducky Video Channel. Trial counsel's failure to object to character assassination and use of inadmissible expert testimony constitutes ineffective assistance of counsel. In Subject VB Infra, this petition contends that Darlie Routier was denied her due process rights under the 14th Amendments because of the state's use of character evidence and the use of inadmissible expert testimony of medical personnel and crime scene technicians. While defense counsel failed to object to the admission of some of this evidence at trial, the record will show that such claims are not procedurally barred because of the state habeas court reached merits of all of these claims without regard to any failure to object. Nevertheless, to the extent that this court should find such claims to be procedurally barred because of the trial counsel's failure to object, we contend in the alternative that such failure constitutes a violation of Ms. Routier's Sixth Amendment right to effective assistance of counsel. The Routier trial was so infected with unfairness that Ms. Routier was denied her 14th Amendment rights to due process. Relevant facts. The state's tactic of character assassination inflamed the passions of the jury and unfairly prejudiced Ms. Routier. As detailed in the Statement of Facts, the trial record is replete with examples of character assassination. From its opening statement, the state made clear its intention to improperly ground its case on character conformity. Attacks by stating that the real Darlie Routier was a self-centered woman, a materialistic woman, and a woman cold enough, in fact, to murder her own 2 children. And the state continued its assault on Darlie by parading a host of witnesses who did not approve of the way that Darlie dealt with the horrible loss of her children, as if there was a right way to grieve the loss of her 2 young boys. Perhaps the most inflammatory piece of evidence introduced at Mrs. Routier's trial was a videotape of a local news broadcast of the graveside birthday party that occurred on June 14, 1996, what would have been Devin Routier's 7th birthday. In the videotape, Ms. Routier is shown singing Happy Birthday, shooting silly string chewing gum, and laughing. The state claimed that it introduced the tape to give insight into this woman. In fact, the portions of the video presented to the jury were out of context. The full videotape, filmed secretly by the Rolette Police Department on June 14, 1996, showed a solemn prayer service held earlier in the day and attended by Darlie and her family. More importantly, it showed that Darlie's family, not Darlie, orchestrated the birthday celebration and brought the party favors and balloons to the gravesite. The secret police surveillance tape also shows Ms. Routier as just one of many people engaging in various activities at the gravesite. That included not only a very brief birthday celebration with children, family, and friends present, but also mourning and remembering the children. The rough timeline for the events on video, as shown on the video timer rather than the actual time, is as follows. Family members decorate the gravesite, and Miss Routier's sister speaks to Devin's and Damon's graves, telling them that she brought silly string and snaps for them. 8-minute. Gathering for prayer service, 22-minute. Prayer service followed by lengthy and quiet gathering of family and friends, 34-minute. More family and friends begin to arrive at gathering for birthday party, 1 hour, 41-minute. Birthday celebration, 2 hour, 3-minute. News interview begins, 2 hour, 4-minute. News interview ends. The Routier's friends and family remain at the site, discussing various matters, including reminiscing about the Routier children, 2 hours, 30 minutes. A person who appears to be Miss Routier's sister states that she obtained silly string and poppers for the boys. The jury was left with only one possible conclusion, that the vignettes of Miss Routier, shown in the news videotape selected by the state, represented how she mourned her children. That type of character assassination was patently unfair to Miss Routier. Repeated use of inadmissible medical expert testimony substantially prejudiced Miss Routier. The state introduced inadmissible expert testimony regarding Darlie's state of mind after the murders. The testimony came from medical support personnel who were not qualified to render such opinions and who spent very short periods of time observing Darlie in the hospital recovering from her wounds. None of these witnesses were proffered as an expert trained in judging the response of others to tragic circumstances. None knew Miss Routier's ordinary demeanor or how she normally reacts to trauma, and none claimed to have treated other mothers who were injured at the same time their children were murdered. Indeed, none would have been qualified as an expert under Dauber v. Merrill Dow Pharmaceuticals. The prosecution's use of this testimony was intended to show that because she did not act in a hysterical manner, Miss Routier must have killed her children, a point the prosecution would ultimately drive home to the jury in closing argument. The medical support personnel testified as follows. Santos, one of the attending physicians, was permitted to testify that most of the time mothers, when they are made aware or told that a child has died, get hysterical. He further testified that they cry and usually tell me I am wrong. He testified there is a lot of anger and a lot of pain. He said that as far as all the mothers he had ever dealt with in the same situation, he had never seen anyone react with a flat effect as Miss Routier did. Jody Cotner, a nurse supervisor, was permitted to testify that Miss Routier was kind of withdrawn and didn't cry very often, and that she wasn't very emotional, and that this was not the emotions that you usually see with a mother. Denise Falk, a nurse who had attended to Miss Routier on the night of the 7th of June, was allowed to testify that she had dealt with people before that have lost loved ones or close relatives. In response to the question, did Darlie Routier's reaction differ from what you had seen in your experience, she was allowed to opine that it was difficult in that she didn't portray any of those characteristics. As a result of the unobjected to admission of this damaging and irrelevant testimony, the prosecutor was allowed to argue. You remember Dr. Santos told you that, of course, he checked on her. He deals with this situation all the time. People that have been seriously injured, people that lose their relatives. That is part of his job. He said he was expecting her to go crazy. Mothers, many times, when they lose their children, don't accept that fact. They want to know where they are. They won't accept it when you tell them they are dead. But not this woman. She wasn't of the demeanor he thought she would be. Flat effect is what he called it. Flat effect. Jody Cotner, who was a trauma coordinator, she had been there 11 years. One of her jobs is to work with people, to inform people that their loved one has died. She has had to do this hundreds of times, she said, to deal with mothers that lose their children. And what did she tell you? There's nothing like it. The bond between a mother and a child. A grief that is unconsolable. They do it in different ways, but they all show it. And she never saw that reaction from this woman. Never saw the reaction she had always seen before. The same with the other nurses who deal with this stuff every day. They have never seen a reaction like that. It was more of a whining, no real tears. I think you all know what they are talking about now. Now all the evidence is in. Repeated use of inadmissible expert testimony and crime scene analysis substantially prejudiced Miss Routier. The significant part of the prosecutor's case consisted of expert testimony on crime scene analysis that should have been rejected on the grounds that it failed to meet the Daubert test for expert testimony. These opinions were supported by non-empirical studies, were unverifiable, and were based on methodology that was incapable of being challenged because the testimony was based purely on his subjective instincts. Former police officer James Cron, for example, was permitted to testify as follows concerning his big picture impression of the crime scene. After a 25-30-minute initial walkthrough on the crime scene, Cron had formed a belief that there had not been an intruder entry through the window. When asked by the prosecutor why he formed this opinion after his initial walkthrough, Cron said only that it's sort of a big picture. It's not any one thing. It was the overall scene, which primarily is a lack of evidence in many cases. But the entire scene indicated to me there had not been an intruder. There wasn't any object or any one situation there. When Cron was asked to summarize the factors he used in reaching this opinion, his testimony revealed that what he had testified to was not fit for expert testimony because, in his own words, this is all common sense. Cron was also allowed to provide his subjective opinion that a glass from the wine rack in the Routier kitchen that was broken at the crime scene was not dislodged by an intruder, but instead that it looked to me like it had been broken there to simulate or stage an offense. A member of the household broke it and planted it there. Finally, Cron was allowed to summarize his opinion as follows. In my opinion, no intruder committed these offenses. The subjective opinion of FBI Special Agent Alan Brantley was also admitted without a Daubert hearing. Indeed, the court amazingly and incorrectly held that Daubert had no bearing on a criminal case. Brantley offered his opinion that in this particular case, in this particular crime scene, that this crime scene had been staged, and in all likelihood, whoever killed both Devon and Damon was someone that they knew very well. It is highly unlikely that such testimony would have passed a Daubert test had the court correctly understood that it applied. Agent Brantley himself noted that his analysis consisted of being aware of the obvious, that it takes no behavioral scientist or no rocket scientist to come in here and talk about those kinds of things, and that it is nothing more than noting the characteristics of the victim, reading the police reports and evidence from the crime scene, and drawing logical conclusions from that information. Legal basis for the claim. Errors in the management of the state criminal trial will result in denial of due process where they are so harmful to the cause of the truth that singly or communicatively they make the defendant's conviction fundamentally unfair. Bell v. Duckworth. The prosecutor's theory of the case, Ms. Routier was cold and materialistic enough to murder her own children, was a direct assault on the fundamental rule of evidence that a defendant's bad character cannot be used to argue that the defendant committed the crime for which he is being tried, or had the propensity to commit the crime. Washington v. Hofbauer. Noting that a prosecutor who dwells on a defendant's alleged bad character in this prohibited manner may be found to have engaged in prosecutorial misconduct. Here, this error was compounded by the introduction of expert opinion that is nothing more than subjective opinion. Emphasis added when an expert witness brings to court little more than his credentials and a subjective opinion, this is not evidence that will support a judgment. Ms. Routier was deprived of a fair trial. Almost all of the state's evidence falls into one of these three impermissible categories. 1. The character assassination of Darlie Routier. 2. So-called expert testimony about Darlie's demeanor after the murders. And 3. Purportedly expert testimony that was introduced to demonstrate that the crime scene was staged. If all of the evidence falling into these three categories had been excluded, as it should have been, the state would have been unable to survive a motion for a directed verdict. The remaining evidence would have shown that Darlie herself had been severely wounded, that her home had been left in disarray, and that an attacker left a bloody sock in an alley far from the site of the attacks. These errors caused Miss Routier's conviction, depriving Darlie Routier of her right to due process. The cumulative impact of the ineffective assistance of counsel and fundamental unfairness of the trial violated Miss Routier's due process rights. As set forth in detail above, Miss Routier's conviction was the product of irrelevant and inflammatory evidence. The majority of the evidence that was presented, or presented and not rebutted, was a result of either the constitutionally deficient performance of Miss Routier's trial counsel or impermissible character evidence, and the expert testimony proffered by the state. Taken As a whole, these errors so infected Mrs. Routier's trial as to undermine all confidence in the verdict. Relevant facts. The state's case against Miss Routier was entirely circumstantial. The only true evidence against her consisted of the following. Mrs. Routier, although herself attacked, was in the room at the time of her boy's murders. The remainder of the state's case consisted of a combination of improper character attacks and questionable physical evidence designed to demonstrate Miss Routier staged the crime scene and murdered her own sons. As discussed in Section VB Supra, Miss Routier's trial was infected with the following due process violations. The state repeatedly presented evidence of Miss Routier's bad character to show she had the propensity to commit the crime. The state proffered testimony of multiple medical support personnel who offered improper expert conclusions regarding Miss Routier's state of mind after the murders. The state introduced expert testimony on crime scene analysis that should have been and was not stricken on due grounds. The due process violations that ran throughout Miss Routier's trial were compounded by the ineffectiveness of her trial counsel, who not only failed to present rebuttal witnesses to contradict the state's theory of the staged crime scene, but dismissed 2 experts who could do so. Trial counsel's conflict of interest also prevented him from introducing a plausible version of the attack, that Miss Routier's husband was implicated in the crime. Taken separately, these errors are constitutional violations worthy of habeas relief. Taken together, they can be absolutely no confidence in the verdict rendered against Miss Routier. Legal basis for the claim. Federal habeas corpus relief must be granted for cumulative errors in the conduct of a state trial where those errors so infected the entire trial that the resulting conviction violates due process. The Fifth Circuit also requires that 1. The individual errors involve matters of constitutional dimension, and 2. The errors were not procedurally defaulted for habeas purposes. When considering claims of cumulative error, the reviewing court must review the record as a whole to determine whether the errors, more likely than not, caused a suspect verdict. Here, the jury's verdict against Miss Routier was the result of prejudiced evidence of marginal, if any, value that infected Miss Routier's entire trial. The deficient performance of Miss Routier's trial counsel, as well as numerous incidences of abused character evidence and the questionable expert testimony introduced by state, constitute independent constitutional errors that infected Miss Routier's trial. Taken as a whole, these errors so infected Miss Routier's trial as to constitute a violation of her right to due process. Darlie Routier is innocent of the crime for which she was convicted. Miss Routier has introduced evidence of actual innocence that exceeds the gateway standard under Schlupp v. Dello, and is therefore entitled to relief for the specific constitutional violations in her case. Miss Routier has already introduced significant post-trial evidence of her actual innocence. A bloody fingerprint left on Miss Routier's glass sofa table the night of the murders has been conclusively determined not to belong to any one of the Routier household. The state witness testified at trial that the print was consistent with having been left by a 5 or 6-year-old child. The state's post-conviction fingerprint expert concluded, however, that he was able to exclude all possible known sources for this print except Mrs. Routier herself. 2 separate fingerprint experts have definitely excluded Miss Routier as the source of this print. Miss Routier has also been excluded as the source of a bloody fingerprint left on her utility room door, the same door through which she claims her attacker fled. This fingerprint was not introduced at trial. Evidence introduced by the state at trial to show Miss Routier staged the crime scene, including blood spatter stains on Miss Routier's nightshirt, blood stains left by a vacuum cleaner, a broken wine glass, and fibers found in a kitchen knife, has been shown to be mistaken, scientifically false, or otherwise insupportable by forensic scientists Terry Laber and Barton Epstein. Laber and Epstein were retained by Mrs. Routier's court-appointed counsel and dismissed by her trial counsel, Doug Mulder. Consequently, Labor and Epstein were not able to complete their analysis, and none of their preliminary conclusions disproving the state's case were introduced at trial. Labor and Epstein have been re-engaged in Ms. Routier's defense and after further analysis have substantiated their initial conclusion that the crime scene was not staged. The scientific and physical evidence that has surfaced since Ms. Routier's trial seriously undermines the credibility of her conviction. Moreover, this evidence has been gathered without any access to forensic or biological evidence in the state's possession, without access to the state's notes underlying pretrial DNA testing, in the absence of any factual discovery or evidentiary hearing at the state level. Evidence of Ms. Routier's innocence will only grow stronger as she is permitted discovery and further investigation in light of discovery of these federal proceedings. When a constitutional error, here Ms. Routier's denial of her Sixth Amendment right to effective assistance of counsel and her 14th Amendment right to due process, results in the conviction of one who is actually innocent, the conviction is not entitled to the same degree of respect as a conviction that is the product of an error-free trial. To establish that a constitutional violation has probably resulted in the conviction of an innocent person, Ms. Routier must show that it is more likely than not that no reasonable juror would have convicted her in the light of new evidence. Ms. Routier's conviction differs markedly from a case like Hira v. Collins, where the petitioner conviction is presumed to be free of constitutional error. Because an error-free trial necessarily instills more confidence in the verdict, petitioners with Hira-type claims must meet a higher standard of review. The precise holding of Schlupp applies only to cases in which a petitioner raises a claim of actual innocence to avoid a procedural bar to the consideration of his other constitutional claims. Schlupp's more lenient standard, however, must also apply to cases such as Ms. Routier's, where the petitioner does not face such a procedural bar. But Ms. Routier's flawed conviction is a direct result of the constitutional errors underlying her claim for habeas relief. To find otherwise would yield an absurd result that only applicants whose habeas petitions suffer from a procedural defect could avail themselves of the Schlupp standard. Put differently, Ms. Routier would be penalized for having a procedurally correct petition, because the analysis of Ms. Routier's actual innocent claim would never come before this court. Accordingly, Ms. Routier is entitled to relief if she establishes that her 6th and 14th Amendment rights were violated, but fails to establish sufficient specific prejudice occurring from any single violation, because she can establish that it is more likely than not that no reasonable juror would have convicted her in the light of the new evidence. The Supreme Court's pending review of House v. Bell may afford Ms. Routier with a freestanding claim of actual innocence. The Supreme Court suggested in Hira that a truly persuasive demonstration of actual innocence made after trial would render the execution of a defendant unconstitutional. While several appellate courts have interpreted Hira to create a claim of actual innocence in the absence of a constitutional error at trial, the Fifth Circuit interprets Hira as dicta and holds that newly discovered evidence relating to innocence is an insufficient standalone ground for habeas relief. The law regarding freestanding actual innocence claims under Hira, however, is now in flux. On June 28, 2005, the Supreme Court granted certiorari based on the holding of a sharply divided Eighth Circuit panel that the petitioner Paul House had not met his burden of proof under either Schlupp or Hira in spite of House's introduction of compelling new evidence that substantiated his innocence claim. The Supreme Court certified the following questions for review. Did the majority below err in applying the Supreme Court's decision in Schlupp v. Dello to hold that petitioner's compelling new evidence, though presenting at the very least a colorable claim of actual innocence, was as a matter of law insufficient to excuse his failure to present that evidence before the state's courts, merely because he had failed to negate each and every item of circumstantial evidence that had been offered against him at his original trial? And what constitutes a truly persuasive showing of actual innocence pursuant to Hira v. Collins sufficient to warrant freestanding habeas relief? The Supreme Court's review in House may very well provide Ms. Routier with a freestanding claim of actual innocence. As summarized in Section D1 above, Ms. Routier has already introduced substantial post-trial evidence of her innocence and has done so in the absence of access to critical evidence in the state's possession or any court-permitted discovery. This evidence alone, notwithstanding additional evidence that will likely surface through discovery, is sufficient for Ms. Routier to demonstrate she is innocent of her children's deaths. Issues under 28 U.S.C. 2254 D1 D2 E1 with respect to the state court's findings of fact and adjudication of the claims. Under 28 U.S.C. 2254D and E, a federal habeas court must presume state court findings of fact to be correct and defer to state court determinations of claim unless the findings of fact can be rebutted by clear and convincing evidence and the determinations can be shown to be objectively unreasonable or based upon unreasonable determination of the facts in light of the evidence presented in the state court proceedings. In the briefing that Ms. Routier will submit in the course of this litigation, she will demonstrate that the state court findings of facts with respect to all the claims presented herein can be rebutted by clear and convincing evidence. Ms. Routier will also demonstrate that the state court determinations of the claims presented herein are objectively unreasonable or based upon unreasonable determination of the facts in light of the evidence presented in state court proceedings. In addition, Ms. Routier will demonstrate a more profound procedural problem with the state court proceedings, the abdication of the judicial function by the state habeas judge to the prosecutor. The state habeas judge performed no function independent of the prosecutor. He had reached no decision before asking the parties to draft findings of fact and conclusions of law. He never held a hearing where he played an active or inquiring role. He never provided guidance as to the results and points he wanted addressed in the final order, and he adopted without any material or substantive alteration the state's proposed findings and conclusions. This process deprived Ms. Routier of one of the cornerstones of due process, a fair resolution of the issues in her case by an impartial decision-maker. Ms. Routier's decision-maker was ineffective, her adversary, the district attorney. As such, nothing decided by the state habeas court can be given deference in this court. To do so would be to inflict anew the due process violation already suffered by Ms. Routier. Prayer for relief. Wherefore, Darlie Lynn Routier prays that the court order respondent to provide this court with a record of all state court proceedings, issue a writ of habeas corpus to have her brought before it, to the end that she may be discharged from her unconstitutional confinement and restraint and or relieved of her unconstitutional sentence of death. Grant an evidentiary hearing so that she may present evidence in support of these claims, and grant such other relief as law and justice requires. Dated November 29, 2005. Respectfully submitted, Richard Burr, Burr & Welch, LLP, State Bar. Lauren Schmidt, Michael Flanagan, Richard Smith, and J. Stephen Cooper, attorneys for petition. Verification under penalty of perjury. I hereby declare that all the factual allegations made herein are true and accurate, except for those allegations made upon information and belief. Richard Smith.